Nick Heath here at Capital Asset Management, and delighted to be joined by senior partner Henry Hood of Hunters Law. Hi there, Henry.
Nick, thank you very much indeed. I'm delighted to be here.
Now, Henry, you specialise in family law, and I just wondered for the viewers and listeners, actually what falls under a family law remit?
It is really everything connected with the breakdown of relationship.
Okay.
And all the ramifications, particularly financial and children, that come with that. Latterly, as I know we will be discussing later, the tasks that we were asked to perform were increased by the extent to which one can protect assets, particularly in the context of some future relationship breakdown, prenuptial agreements or nuptial agreements generally. And so that has been added to our list of tasks, often requested by clients. But that is what we mainly do. It's the financial implications and ramifications of the breakdown of mainly marriages, but otherwise civil partnerships or simple cohabitations, which are often the most complicated.
And talk to me a little bit about this. So if somebody's going through this particular life moment of which, divorce, marital breakdown would be one. When people kind of arrive at your door, for want of a better term, what kind of situation is that? Do they typically find these people in?
Well, and it's not uncommon for someone to have come to talk to us before when the possibility occurred to them to see what the future might hold in the event that this event did occur. Otherwise, the way in which clients find their way to us is many and legion. It's not always easy to know quite how they do so. There was anecdotally an old roue of a divorce lawyer who used to who was very social and would slip into a neighbour at dinner parties. Pocket. I know, my dear, that you're very happy married now, but should that ever not be the case,
yes.
Here's my card. But that's not really the way it's done. It's quite difficult to market divorce, as you can imagine. But so we find that our clients find our way to us through word of mouth mainly. It's the work we've done with existing clients and that gets known by their friends and contacts. Also, being known to be able to be a safe pair of hands in these terribly difficult times, because they are enormously difficult processes or events in people's lives. Other professionals from whom a family might seek advice is another way in which, if they know of us, then that's another way in which clients find their way to us.
And clearly, with something like divorce, that type of life moment, emotion is going to be a overriding kind of feeling. To what extent does somebody have to deal with their spouse directly during those proceedings, as it were, or is it all through?
It's really what suits them. I mean, there are moments of you're never going to get on worse than when during this period. I'm strongly of the view that hideous as the process is, it can be one of growth, and that relations, hopefully, if the job is done well, will improve, particularly if there are children. There has to be a continuing and ongoing relationship. It's hellish if, as does happen, parents have to sit on the other side of a touchline seeing their boy play football or rugby, or different parts of an auditorium to see the school play, etc. So hopefully one can get through this process, which is a necessary one, retaining the relationships that have to continue, particularly if there are children, and that is something that divorce lawyers are very aware of, and that absolutely no point in there are aggressive divorce lawyers. It's undoubtedly the case, and one knows who they are sometimes. But of course, you've got to be robust. You've got to fight your client's corner, but you also have to have a conversation. You have to have communication going on beyond this process.
And would I be right in thinking that, typically speaking, one particular individual in that relationship would have oversight of the finances within the family?
Frequently.
Yeah.
And it's where people like your good selves come in. A classic scenario that we might have is where we live and work very closely with a particular client. Let's say it is the economically weaker client, classically, stereotypically, the wife, who has not been involved in the financial accretion of wealth, has been doing other equally important things, but is not as well versed in running finances. The result of our work will require them going forward to manage finances. And one of the key things that we need as the divorce lawyers, because we're not going to remain in that client's life forever, but we need to know that when they leave our doors with their whatever they have, their award, that's going to be properly managed, and so people like capital asset management are very important in making sure that pot, that award, is properly managed.
Yeah, I mean, what we find is you can distill all of this down on that side to one question, which is really, typically speaking, will I or will we be okay?
Yeah.
You know, whether that's somebody that's divorcing is then having to sort of understand their finances, or whether it's, you know, family thinking about retirement, for example. It really does distill down to that. And, you know, our role is to help people find that visual pathway quite often forward around their finances.
I never met my grandmother, but my grandmother used to have a saying, according to my father, that she would never even buy a new hat without consulting a solicitor. I rather think the same about you know, someone who has the sort of client that I've just been describing, who has a limited amount to keep her going, needs to be able to have honest and frank conversations. Can she afford this? Can he afford that? And for that to be an ongoing management process of monies going forward, because that is so key. One of the problems that you have is that the manner in which awards are capitalised, identifying the capital amount that is thought to be sufficient to keep someone going through and to meet the needs going forward, has some pretty optimistic investment returns built into it. And so it's not easy, I don't imagine, for people in your circumstances always to meet those expectations. But there we go. That's the beast we have to deal with, and there's not much. I have tried to argue alternative Duxbury arrangements, but it's not succeeded yet.
So you mentioned earlier that we were going to sort of touch on a couple of, I guess, key areas of divorce and family law. One of those is around nuptial agreements. And I find that's kind of just a term that's kind of bandied around, right? It's like, oh, get a prenup or you know, get a postnup. It's kind of language bandied around, but I think it'd be really helpful for the audience to get quite specific around this. And I guess the starting point with this is, are nuptial agreements legally binding?
Well, it's a question that we're frequently asked. And the question that we would give now is very different from the answer we would give now is very different from the answer we would give 20 years ago. Because the answer is yes, they are, but it's not as the result of any legislation. There is no legislation. The Law Commission has recommended such legislation in 2014. It gave a massive thumbs up to the concept of prenuptial agreements, but the regime of putting together nuptial agreements really only began with the case in 2009 called Radmacher and Granatino, which is a case that got all the way to the House of Lords, and where the court created the law that is now operated in nuptial agreements, whereby it said that where parties have entered into an arrangement, fully aware of its implications and without duress, then those agreements should be upheld unless their application creates significant unfairness. I don't quite exactly. I easily can. It's paragraph 75 of the relevant judgment, if anyone wants to look at it. And that is what the law is, and that's what's been guiding our thoughts ever since.
Okay. So what does that actually mean in practice? So when might a court not uphold a nuptial agreement, for example?
As I say, they're not strictly binding, so it is always possible to have a crack at them.
Yeah.
And that's the difficulty.
And this is the thing around fairness, or
exactly. Well, fairness and construction.
Yeah.
It is. People need to know what's what, so they need to have proper legal advice. And the party that needs the legal advice most is the economically weaker one, the one that might be signing away some element of their claims.
Yeah.
they're the ones that need to have more important. It is most important to have legal advice. Indeed, the irony is that it is the other party whose assets are being protected that needs the other party to have the best legal advice, so that they can't then later say, "I didn't know what was going on," etc. The legal advice has to cover what might apply in the absence of an agreement. It needs and it needs to advise what the effect of the agreement is. Mm-hmm. That legal advice needs to have also incorporate what the finances that are likely to be relevant are. So that she needs to be, I don't say full financial disclosure. We're not talking about enormous amounts of bank statements and accounts, etc., etc. But the party entering into an agreement, if asked to limit, put a cap on the claims that might be made later on, needs to know what the relevant finances are. What does that? What finances exist at the moment? What might exist in the future? There needs to be an understanding of that. So it's legal advice and financial disclosure, and then it must not be signed off or executed under the pressure of an imminent wedding. So the good practice suggests that there needs to be at least 28 days between the signing of an agreement and the wedding itself, and if possible, do it earlier.
Okay. And so, when is it worth having a nuptial agreement in place?
Well, the paradigm circumstances which were identified in the Law Commission report in 2014 for that would make a prenuptial agreement entirely appropriate would be if one, there's assets that come from outside the marriage.
Okay.
So inherited assets.
Yeah.
Assets that existed before the two parties get married, a significant wealth created before the marriage, gifts from other members of the family, and other inheritances. That's the first sort of paradigm circumstance. And the other one is where parties are entering a second marriage, where there exists well-established and mature financial arrangements and obligations, an existing family, etc. Absolutely prime territory for a prenuptial agreement, not least because it allows, if the children of an earlier marriage can often see a new wife, let's say, in these circumstances, as a threat. Or know what's going to happen if the marriage breaks up, and whereas they would like to welcome their father's new partner, difficult to do so unless, or at least a prenuptial agreement can really help all such fears being put to rest. Yeah. And so those are the two. But the reason the prenuptial agreements have now got such traction is there is a wish for people to make autonomous decisions, and so you can, within reason, put whatever you like into a prenuptial agreement. But at the end of the day, and this, I suppose, is the final category, which I probably should have mentioned earlier, is that having gone through the financial disclosure and the legal advice, the effect of a prenuptial agreement must not be unfair. Okay. So any idea, and when we see this, I've seen it more years ago, but where there may be the attempt to ask someone to sign up to something which completely rules out any claims at all. In circumstances where that person might be left unable to meet their needs, by which I mean accommodation and income, really, to a level that reflects the sort of standard of living during the marriage, then it's quite likely that would be a reason why a court later might say, on balance, we're not going to uphold that agreement. So there's no point in doing an agreement that does not meet need. Basically, that's the bottom line. The extent that finances exist to do so, needs have always got to be met. But above that, then prenuptial agreements can say really whatever anyone wants.
So I'm really interested to know that. So is this a case that I don't know, couple come into your offices, they have a list of, is like a starting point for negotiation, if you like, around what a prenup is and isn't.
Yes, quite how you get it going is often difficult, but one of the problems is that there has to be independent advice. So it is difficult. I don't say completely impossible, but difficult to to talk to a couple together,
Yeah.
except perhaps at the very, very early stages where you say, look, this is what could be possible, but one of you needs to go to that solicitor and I'll act to the other one. Because you have to have independent advice. It is not where there's no conflict between the interests of the two parties. So that and that has a cost consequence. But that is the way it has to be.
And I wondered, like, if your spouse just says that I just don't want to have a prenup agreement in place, is there anything you can do to protect your?
Indeed, and that does happen. I mean, they are. There's no way of suggesting that prenuptial agreements are romantic.
No, they're not.
And people may have sort of very distinct sort of emotional objection to doing something like that, and in those circumstances, and I have had circumstances where that marriages have come unstuck as a result, or not taken place as a result of that. But no, there are ways in which you can, without a prenuptial or falling short of a prenuptial agreement, make some protective measures or take some protective measures. And this flows from the concept of marital and non-marital assets. Essentially, the law in divorce at the moment is that marital assets, i.e. those that are created during the marriage and as a result of both parties' contribution, so the wealth created during the partnership that is the marriage, will be divided equally, probably. It can be in other proportions, but equally. Whereas assets that are created otherwise than during the marriage, particularly as I described before, premarital or inherited, they would, all other things being equal and everything else being sufficient to meet need, would be left out of account. Now, it is possible, the court seems to think, it's not always easy, some judges take different views, for non-marital assets to become marital by, for instance, putting them into joint names, or putting them into houses that are lived in as part of the marriage, or being used to meet the standard of living that the marriage, the parties wish to lead. In those circumstances, the non-marital nature of those assets can become eroded. And so where you don't have a prenuptial agreement, and if you want to make sure that such assets remain intact, keep them separate. Don't mingle them. That's the word we use in the judgment. No mingling going on, please. And have ways in which you can identify that a certain body of assets is entirely distinct and refers back to a previous life or sources that are outside the marriage. So that is a principal way in which defences can still be erected, falling short of a nuptial agreement.
So if somebody's thinking about this, we should have a prenup in place. What's their next step? What do they do next?
Give us a call.
Yeah. Simple as that.
Give us a call. We have a standard. The form that prenuptial agreements take is quite fairly standard. The people that deal with them a lot in London, particularly, would recognise there are certain sort of types, certain models one gets one recognises, and so it's a question of talking, seeing what the parties or what the particular party, particularly the one that wants the assets being protected. And let me tell you, one of the complications that we meet in doing this work is that it's often not the party getting married; it is their parents.
Okay.
And it's often the prenuptial agreement is the first step in devolution of assets going down. I'm not going to let this house or body of money pass down to you until you've got a prenuptial agreement in place. Yeah. In those circumstances, the actual person getting married, who is our client, often doesn't know what there is, and that can cause difficulties. When they don't yet know what they're going to get, how do you tell the other side what's going to be involved? And so that's sometimes quite a bit of a difficult juggling act, in that the impetus and is coming from the parents, saying this is what will be put in place. Please go and see Henry Hood or whoever it might be at Hunter's, and they're not quite sure why. And so then you've got to sort of rather gently say, well, look, these conversations have to be had. You need to introduce your fiancé, who's equally sort of looking forward to the wedding and equally unaware of why they should be going through these slightly sort of unromantic processes. But it is so those are human issues that we have to deal with as a prenuptial agreement is put in place. For that reason, start as early as you can.
Yeah. And is it the case that these agreements are reviewed on an ongoing basis? I guess
Very good question.
Wealth and assets come in.
Very good question, because if you do have, I mean, the process of doing one is not necessarily that much fun. Some are easier than others, but I mean, you want to get it parked and put in the bottom of a drawer before the invitations go out and all that sort of stuff. Do you want to do it again? Because in order to keep a prenuptial agreement fresh, it would be a good idea to, and this has to be the right advice, is to look at it periodically, either on a regular 5-10 yearly basis, or when there are events take place, like children arriving, etc. Have a look at it, because it becomes less and less easy to, I mean, an agreement becomes perhaps less and less reliable the older it is. And if you are trying to rely upon it literally 30 years after it was created, when everything has changed, a lot more money has been made, or who knows what changes might, it makes it easier then to say, well, look, it was all very well and that was very apt for the circumstances that applied then, less so now. So, yes, I mean, it is, reviews are to be recommended. Okay. I don't say that necessarily terribly always are, but they're to be recommended.
And just finally, just give us an idea of the cost of setting up a prenup or post-nuptial agreement.
I think that it's the bottom line. I don't think that you could expect that for the side that's going to be doing the drafting of the agreement, and you need therefore to make the disclosure of the finances, that you'd expect to get away with much less than £3,000, in my view. Okay. Much more can be involved, particularly if there's extensive negotiation, which in a sense is something to be welcomed, although you don't want necessarily to be negotiating with the person you're about to be married, but for our point of view and the legal reliability of a prenuptial agreement, the extent to which it's been quite rigorously negotiated, no, I want more, that's unreasonable, etc., makes that agreement that much more reliable, because then if it is ever challenged and the file is looked at all those years later, and it's quite clear that a rigorous exchange of views was undertaken, that's going to make that agreement more reliable, but that may come at a cost. Yeah. And so there have been bills that are very much more than the 2.5 to 3, which I think is the bottom line. But and then the costs do increase. If you do have, as we have, certain amount, matters where parties might move abroad, or they might have other jurisdictions where life might take them. Particularly if there is one, obviously, if one party is American, etc. It may well be that the eventual divorce, which is, I'm afraid, the hypothesis on which one's operating, that is, the marriage will fail. That's why they're so essentially unromantic. Then you may wish to have the agreement that is reached here kind of registered, or not in a formal sense, but sort of recorded, or having some form of American imprimatur. Okay. So American law then looks at it and saying, yes, that will work here, or you re-sign it over there to make sure that it's effective. And the same would apply to other countries in the world as well. But so that would come with greater cost. But so I don't, there is a cost involved. There is, but they now have become mainstream, essential tools particularly in the devolution of wealth down the generations, and so they're not to be disregarded, and in the way that it might have been in the 1990s or the run up to the Radmacher case, where they weren't worth the paper they're written on. That's why people ask me and say, prenups don't work, do they? And they don't want to say they do. I mean, you can't ignore them, particularly. And I think that you would, if wealth managers, advisors didn't consider a prenup in certain circumstances, they would be at fault. So I think there has to be a.
Yeah, I think we with a lot of these, I mean, really, it's in exchange for peace of mind, isn't it?
Yeah, it is an insurance policy.
It's exactly an insurance policy. So it's as we will both well know, the stats around the number of people that don't have wills in place, for example, are still absolutely shocking, and actually cost now around creating a will is not particularly prohibitive, but people don't have wills in place, and you're right, okay, it feels unromantic, however, it is a peace of mind thing, and it is the right thing to...
But it is, as you say, it is the insurance policy, because what you're achieving with it is effective certainty, and everyone knows what's what. If it's done right, no one's going to be wanting for money. They're not going to be sort of held in some sort of incredibly unfair scenario, but they all know what the score is, and therefore hopefully it'll never be looked at again. The marriage survives, and then it'll just be never. And so you then think, well, what's it like any insurance policy you got was £3,000 not well spent. But if I'm afraid to say the balloon does go up and there is a divorce, then there's no point having very expensive and terribly damaging litigation. If at the end of the day the courts can say, well, look, you know, that's what I'm going to do. And now is the process by which the courts will short circuit and fast track cases where proper prenuptial agreements are in place does exist. And so it is a way not only of has all these advantages of making a wider family less anxious, but also it basically says, you know, if the future, if the marriage doesn't last, at least we're not going to have 18 months of bloodletting litigation.
Yeah, thank you. So Henry, another area that particularly interests me, and we get questions about this quite a lot in my line of work, is the role of trustees in divorce. And so I wondered, when might trustees become involved in divorce proceedings? It's
an interesting and quite complex topic. It flows from the obligation that all parties going through a divorce process have of disclosing what their assets are, revealing what money is available. And to the extent that a party has trust interests, the background detail and documentation of those interests, and particularly how much they're valued at and what money flows, is required. And so it is in essence, to start with anyway, a process of disclosure. And the disclosure requires the beneficiary to produce, or at least the other side would expect and ask for them to produce the documentation that governs and details those trust interests. So that, at its starting point, is where trustees become involved in the divorce process. There, it goes on as to the extent that there might be a way in which the divorce process might tap in directly to those trust assets. But it's quite a rarefied aspect, but we can cover that if you wish.
Okay. And might a trustee be required to provide the court and the other side with information about the trust and its assets?
Yes. I mean, the starting point would be, let's take a trust where an interest is vested. The beneficiary has a defined interest in a trust and receives or otherwise income or capital. In those circumstances, the very starting point would be for the trust the divorce process, to be provided with those bits of documentation the beneficiary can themselves ask the trustees to provide them. So a starting point would be trust deed, any variations thereof, recent accounts, and those are the sort of basic, the basic documentation which provides the structure, identifies what the value of the trustee is, or more particularly the value of the beneficiary's interest is. It becomes much more difficult, and there's a lot of jurisprudence around the documentation that might reflect upon or govern or reveal the trustee's own thought processes, the exercise of discretion. So where you have a discretionary trust as opposed to one where the interest is vested, and where that the trustees would, if they're doing their job properly, protect that discretion and make sure that it's one that they have their own thought process and rules. There may be letters of wishes from the protector or the settlor, which governs the exercise of that discretion. That is much more difficult, and it's less likely that the process would be entitled to those documentations, minutes of trust meetings, letters of wishes, as I say. It may also be a difficult area.
Okay. And can trustees be ordered to make a payment from trust assets to the beneficiary's spouse?
A very hot topic. Of course, the court's powers are limited to the people actually going through the divorce. The trust is not going through the divorce.
Yep.
But there is in the 1973 legislation, which is still the governing, the Matrimonial Causes Act 1973, which governs all our work really, has within it the power of the courts to vary a settlement in circumstances where a trust is considered to be a nuptial settlement.
Okay.
A nuptial settlement is there's a wide definition of what a nuptial settlement is, but essentially, and by way of illustration, a nuptial settlement might be a settlement set up by perhaps one of the parties themselves, relating to money they already had and benefiting themselves or both parties to the marriage or wider members of the family, or a settlement set up during the marriage or in that expectation with the intention of benefiting the parties to the marriage. Such a settlement could well be considered a nuptial settlement, which would be vulnerable to the powers the court has, if so minded, to vary the settlement. And I contrast that with, let's say, a dynastic settlement made 50 years ago, where the interest of the present beneficiary is simply as part of the rolling generational process. That is most unlikely, I would have thought. Who knows what the particular details might be, but that is much less likely to be considered to be a nuptial settlement. With the first, a nuptial settlement, the court's powers to vary are absolute. They can vary to the full extent of the trust. They could redraft the trust, and if they wanted to do so, they could so provide that all the money within the trust be deployed to meet the needs of the divorce process. And in those circumstances, an order would be made against the trustees themselves.
Okay.
Where you have a dynastic asset, there is no nuptial settlement element, and the court would not consider it to have power to make any order against the trustees at all. And in those circumstances, the manner in which the court might tap into, if it wanted to do so, the assets within the trust is much less direct. It really extends only to the expectation that the judge, the court might have, that the trustees will, if asked to do so, provide money to the beneficiary to meet an award that the court makes. And so the court might make an award against a beneficiary in the expectation that the trustees will help that beneficiary to meet that award. Okay. But it's that indirectness that there's no in those circumstances there would be no power for the court to make an order against the trust itself.
Okay, and could trustees be made parties to litigation? So, I guess what would the implications of that be?
Well, they could, in circumstances where a nuptial settlement is in the offing or is contended, then yes, they would be made. It's almost certain they would be made a party of the proceedings, so that an order can be made directly against them, if the court is persuaded that it is a nuptial settlement. So yes, in those circumstances, the trust would be made party of the proceedings. There are lesser orders that can be made against trustees, and particularly for disclosure. And so and trusts would, generally speaking, wish to avoid that. So it is the trustees will always have to consider what their obligations are as trustees of the settlement, and to what extent, in the context of those obligations, it would be appropriate to assist the process to the extent they can. I think if trustees were simply to say, "You're not getting anything from us," that makes them more vulnerable to a court cross at being kept at bay in that way, making an order against them. Yeah. As a well-known family judge said a number of years ago, there is nothing that makes a family judge's antennae quiver at the prospect of a trust, and one party saying, "Well, I may receive large amounts of money from that trust on an annual basis, but it's not me," and that's obviously beyond the court's powers. You might well find a judge in those circumstances doing their damnedest to find a way in. So I think a degree of compliance, a degree of cooperation by trustees is generally speaking a good idea. And so that would be my advice generally.
Okay. So I guess the final question on this actually is, should trustees instruct lawyers if they are contacted in respect of a beneficiary's divorce proceedings, and can they use the same lawyers as the beneficiary?
In circumstances where the trustees think that they may be involved in a divorce, the second of those questions is the easy one to answer. No, they should not employ the same solicitors as the beneficiary, because the trustees' interests are very different from the beneficiary's interests. There may well be a scenario where the trustee is saying, "We're not going to provide the benefit that the other side is saying that the beneficiary should receive. And in those circumstances, the beneficiary does not want to be tied by the same solicitors, as it were, because very different answers. There may be an innate conflict, essentially, between the interests of the beneficiary and the interests of the trustees.
Yeah.
So, but in answer to your first question, yes. I mean, where there is a real prospect of trustees being sucked into a process, yes, they should have solicitors to advise them. And as to what their role is in the context of the divorce that is ongoing. So in such a in meetings, etc., if the trustees were playing a part, they would have separate representation. It has a consequence, of course, but no, you need to keep it separate. And I think that it is much easier that way for the solicitors if they're not having to ride two horses.
Okay. And tell me a little bit about Hunter's Law as a firm. Tell me a little bit about
Thank you. Hunter's Law is what we might refer to as a full-service firm, in that we seek to act for and are interested in advising individuals of reasonable sophistication and wealth in all the sort of legal needs they might have in life. And so I lead the family team, and so I deal with that difficult area of life. We have the wealth management, which obviously has a significant crossover with capital asset management. The task of giving general advice, whether, as I say, my grandmother always wanted to consult her solicitor if she was going to buy a new hat. It's something that is a sacred role for individuals for whom we may have acted for generations. But obviously, wills need to be drafted, trust needs to be created and managed. People die, so there's probates, and there's extensive tax planning that is required. But it is the process by which we advise families, and we are a trusted advisor. We like to think of many hundreds of, indeed even thousands of individuals and families, some of whom we've acted for many years. People buy and sell houses, and so we have a very significant property team. People do fall out with each other, so we can litigate. People give money away, so philanthropy is a significant part of our work, and how those philanthropic matters are structured and dealt with, and that with our larger private clients, that often is a significant part of the work we do. And then, as I said, the process of how our larger clients have managed their affairs, whether they're estates or whatever, involves commercial interests, and so we have a commercial team as well.
And what is it particularly about family law that you, I don't know if this is the right term, but enjoy? What's...
I do enjoy it. Yeah. I think it is, every single day is different. I genuinely think that I have the family laws do have the capacity to, and have the ability and power to make people's lives better. It's a hideous process that our clients are going through, but I think that we are able, and if our job is done right, it is a process of growth, and how to get clients through to the end of that process with causing as little collateral damage as possible is one that is a fascinating one. There's a significant element of academics, as I've described with prenuptial agreements. There's only one act, but there's a lot of judgments, and so the law is changing all the time with individual judges, and now we have significant differences of view on the High Court bench on a number of issues that are relevant to our world. But keeping an idea of where that might be going is a fascinating one. So it is a very, I find it a very rewarding way of spending a day, and it's kept me interested and occupied for a number of years now.
Yeah, that really comes across in our conversation. I think it's interesting in the wealth management space, for example, people will often think it's about numbers and investment markets and all these things. And one of my colleagues, Don Fraser, one of the chartered planners, says actually it's a caring profession. That's actually what it's about.
No,
we're helping people transition from particular life moments and hopefully into a better position further down the line, both financially and emotionally. So all of those kind of aspects feed into it, and that's why I love what I do, and clearly you love what you do
Indeed.
too.
Yeah, absolutely, couldn't agree more. So it makes for, and very nice people do the same work. So I enjoy the people I work with, and so it's as I say, it's kept me busy and occupied for a number of years.
Listen, it's been fantastic having a conversation with you.
Nick,
You've shared some
much.
really great insight into the areas of obviously divorce, family law, nuptial agreements, trustees. We've covered a lot of ground, but really appreciate your time, and thank you for watching and listening.
Thank you very much.
Thank you.